In a dramatic turn of events, the Trump administration has been ordered by federal courts to reinstate 24,500 federal employees. This landmark decision has sent shockwaves through Washington and left many wondering about the fate of the affected workers and the future of the federal workforce. The court rulings, coming after months of legal battles, have exposed deep divisions within the government and raised critical questions about the balance of power between the executive and judicial branches. The road ahead remains uncertain for both the reinstated employees and the agencies tasked with reintegrating them. The court orders mark a significant setback for the administration's efforts to reshape the federal bureaucracy. The reinstatement of such a large number of employees will undoubtedly have far-reaching consequences for the affected agencies, potentially disrupting ongoing projects and impacting morale. Moreover, the legal battle has highlighted the potential for conflict between the administration's policy goals and established legal procedures, adding another layer of complexity to an already intricate situation. In February 2025, the Trump administration announced a sweeping workforce reduction plan aimed at streamlining the federal government. This plan, which targeted probationary employees with less than 1 year of service, resulted in the termination of approximately 24,000 individuals across various agencies, including Treasury, Agriculture, and Health and Human Services. The administration justified these actions as necessary measures to improve efficiency, reduce bureaucracy, and ultimately save taxpayer dollars. They argued that probationary employees not yet fully integrated into the system were less likely to disrupt agency operations upon dismissal. The mass firings, however, were met with immediate backlash from employee unions and advocacy groups, who condemned the move as unjust and potentially illegal. Critics argued that the administration had circumvented established procedures for workforce reduction, particularly the reduction in force regulations, which mandate specific notification timelines and criteria for layoffs. Furthermore, concerns were raised about the impact of such drastic cuts on the functionality of essential government services, particularly in light of the already existing staffing shortages in many agencies. Following the mass firings, a wave of lawsuits were filed by affected employees and their representatives, challenging the legality of the administration's actions. These lawsuits argued that the terminations violated federal law, particularly the RIF regulations, and that the administration had overstepped its authority by bypassing established protocols.
Two federal judges, William Alsup in San Francisco and James Breder in Baltimore, presided over these cases, ultimately issuing rulings that would have significant repercussions for the administration's workforce reduction plan. In their rulings, both Judges Alsup and Breder sided with the plaintiffs, declaring the mass firings illegal and ordering the reinstatement of the affected employees. They found that the administration had failed to adhere to the proper procedures outlined in the RIF regulations, particularly regarding advance notice and justification for terminations. Judge Breder went further, stating that the government's claim of performance issues as a reason for termination was unsubstantiated and appeared to be a pretext for circumventing legal requirements. These rulings represented a significant rebuke of the administration's actions and underscored the judiciary's role in safeguarding the rule of law.
The rulings have not only reinstated the employees, but also sent a clear message about the importance of following established legal procedures, highlighting the judiciary's critical role in maintaining checks and balances within the government. Section 4. The administration's response: a battle of wills. The administration, however, remained defiant in the face of the court rulings.
Press Secretary Caroline Leavitt issued a scathing statement condemning the decisions as absurd and unconstitutional, accusing the judges of overstepping their authority and infringing upon the president's power to manage the executive branch. Leavitt argued that the president, as the head of the executive branch, has inherent authority over hiring and firing decisions within the federal government, and that the court rulings set a dangerous precedent by interfering in this executive prerogative.
The administration quickly filed appeals against both rulings, signaling their intent to continue fighting the reinstatements. This legal battle is expected to be lengthy and contentious, with potentially far-reaching implications for the balance of power between the executive and judicial branches. The outcome of this case could have a lasting impact on the president's ability to shape the federal bureaucracy and implement their policy agenda. Section 5, the long road ahead, reinstatement, and uncertainty. Despite the ongoing legal challenges, federal agencies have begun the complex process of reinstating the 24,500 employees, many of whom have been on unpaid administrative leave. This logistical undertaking presents significant challenges for agencies still grappling with the fallout from the initial firings.
The sudden influx of returning employees has created logistical headaches as agencies scramble to reestablish work schedules, reassign projects, and address potential gaps in workflow caused by the months-long absence of these employees.
For the reinstated employees, the future remains uncertain. While relieved to be back at work, many face financial strain after months without pay, and the ongoing legal battle casts a shadow over their long-term job security.
The possibility of another round of firings if the administration ultimately prevails in court weighs heavily on their minds.
The Trump administration's workforce reduction drama is far from over, with its ultimate resolution likely to have lasting consequences for the federal government and its employees.